Yes.
From the daily list, item number 1.
Please, Your Lordship. Lordship, here, this application will be challenging the order of the CAT. Lordship, Lordship, can you come to page?
Have you given notice?
No notice. This is a motion stage, Your Lordship.
That you have to give notice.
It's a sole private respondent, Your Lordship.
Yes. When you move an application, you have to move it upon notice. Give notice.
We'll take steps, Your Lordship. After the
This is a writ petition
Yes,
against
it's
the
a
order
writ
of the
petition.
tribunal.
Yes, Your Lordship.
Yes, you give notice, then we will admit it and give directions or affidavits. If you want, if you are praying for stay, pray. But it should be upon notice to the other side.
We'll
Why
take
are you
that.
looking so surprised? This is usual practice.
We'll take that steps, Your Lordship.
This is a writ petition
Writ petition, Lordship.
challenging the order dated 2nd May 2024 of the Central Administrative Tribunal at Guwahati. Advocate on record for the appellant is directed to effect thus the service of this application on the respondents and file an affidavit of service before the returnable date. List this application once again on 9th December
Your Lordship.
for admission and any other order that may be warranted.
Highly obliged, Your Lordship.
Item number 2.
What is this miscellaneous case?
May please, Lordship, this is an application to substitute for substitution, Your Lordship. As per the order,
What is
dated
miscellaneous case is for what?
20.
All right.
Yes, Lordship. What happened in this case, Your Lordship? The writ petitioner, earlier writ petitioner.
List this writ petition along with the miscellaneous case. Yes?
The writ petitioner who filed the writ petition, the 233 of WPC 233 of 2023, the writ petition challenging the order of the CEM of GHD, Garo Hills Autonomous District Council. The CEM is a chief executive member of Garo Hills District Council, have passed an order against me. Against that order, I have come and filed the writ petition before the learned single judge, where we decided and dismissed my writ petition. Now, after the order of the writ petition, the writ petitioner expired. Now the niece and the son-in-law of the earlier writ petitioner has filed this appeal, and on the earlier occasion, this court has directed to file an application to substitute on place of that person who has been expired. So this is an application, Your Lordship. So I have enclosed the death certificate and also the resolution by the clan members who authorize that I should be the successor Nokmao, that successor of the late writ petitioner, my lord.
When did the death take place?
Death take place, my lord, that is on 01/5/2024, on 1st May 2024. Death certificate, my lord, I have enclosed, Your Lordship. That is,
No, that is all right.
yes.
And when was the judgment pronounced?
Judgment pronounced, my lord, that is on 23rd April 2024. Yes, after the judgment was pronounced. It was on 23rd April 2024. I've enclosed the judgment also in my appeal memo, Your Lordship. That is at relevant page, page 147, my lord, in the appeal memo. Annexure 4.
Before that, the appeal had been preferred.
Yes, Lordship. Before, no, after his death, Lordship. After the expiry of the late appellant, late writ petitioner.
No, he died on 1st May,
1st
May
May
24,
2024, my lord. Yes.
and judgment was pronounced.
23rd April 2024.
And appeal was filed.
Appeal was filed, my lord. 26 July 2023. No. That's the lordship. Is appeal. Yes, 12 July 2024. 12 July 2024. 12/6/2024.
12 June.
Yes, lordship.
So you have filed an appeal in the name of a dead person.
No. By the person who is the appellant hearing, because not in the name of the dead person. The appellant who is before this court, they are the niece and the brother-in-law of the late writ petitioner.
At that time, you should have taken leave of the court. You have already filed it in their name.
Yes. At that time, we filed an application, but that order reflected, my lord. Page 11, my lord, my miscase application.
They have already filed this appeal.
Lordship.
Sojila Sangma
Sajila, lordship.
and her husband Sinchak Marak,
Lordship.
they are already appellants.
They are already appellate. So we file an application for the leave application, but then court says instead of filing the leave application, file the application to substitute. That order was there, lordship. That order dated by this court, your lordship, on the 29/07/2024.
If you read order 22, when the proceeding is pending,
Lordship.
if one of the parties dies, it is substitution.
Yes.
Here the proceedings have ended by pronouncement of a judgment and order. Appeal is a fresh proceeding.
Lordship.
Between judgment and order and filing of the appeal, the petitioner died.
Lordship.
Therefore, before filing, you should have taken leave to institute the appeal in the name of the heirs. There is no substitution.
Yes. Yes, Lordship. Actually,
Because you could not have maintained the appeal
yes,
in the name of a dead person. All right?
Lordship.
Neither could you have maintained the appeal in the name of the legal heirs without the leave of the court.
Lordship.
So you should have prepared the appeal in the name of the legal heirs and taken leave to file it.
Yes,
No
Lordship.
substitution. Because there is nobody to substitute. He is already dead.
Yes, Lordship. Yes, Lordship. Earlier occasion, Lordship, I have exactly.
Anyway, you have taken out an application before the bench presided over by the former Chief Justice
Yes.
has dismissed it and given you leave to file a fresh application.
For substitute.
This is the application, we will regularize it. Paragraph. We noticed from the records that there was some flaw in the procedure adopted by the applicants. The original petitioner, paragraph, died on 1st May 2024. Full stop. The judgment and order under appeal, no, sorry, strike it out. The judgment and order under appeal had been passed on 23rd April 2024. Stop. On 1st May 2024, the original petitioner had died. Full stop. On 12 June 2024, the instant appeal was filed by the present applicants, the heirs and the legal heirs and representatives of the deceased petitioner, together with an application MC bracket WA bracket closed number 23 of 2024 for substitution. Due to some technical defects, that application was dismissed. By the bench presided over by the then Chief Justice with leave to file a fresh application. Paragraph. We only observe that the appeal could only have been filed by the legal heirs and representatives of the deceased petitioner upon obtaining leave of the court. Full stop. There was no question of any substitution because before filing of the appeal, the petitioner was dead. Full stop. Therefore, his legal heirs and representatives needed leave of the court to file the appeal. Full stop. However, to avoid multiplicity of proceedings and for the ends of justice, since the appeal has already been filed in the name of the legal heirs and representatives, we regularize the same by allowing this miscellaneous application with retrospective effect from the date of filing of the appeal. Paragraph. The registry of this court is to act accordingly. Disposal of.
Your Lordship, in this matter,
Yes?
I'm appearing for respondent, Your Lordship.
Yes.
They are the private respondent.
Please record your name.
I'll accept the notice for respondent 1, 2, and 3, Your Lordship.
There's a
Nothing
private.
has to go for the private respondent, Your Lordship.
Recorded. All right.
Item number 3.
As soon as possible.
I am appearing for the respondent number 2 and 3, my lord, income tax.
Lordship, by the last, yesterday, Lordship had passed an order for me to file a miscellaneous application, Lordship. I have filed it. It is numbered 207. Bringing into record the new notices served on me for recovery, Lordship.
Where are you stationed, Mr. Counsel?
My lord, I am from Guwahati, lordship.
Okay.
So, my lord, may I submit, lordship? In this case, lordship, pursuant to the assessment order, my lord, they file a revision petition before the commissioner, my lord, the respondent number 2. And my lord, that was, my lord, disposed of, my lord, on, my lord, 27/3/2004, my lord, pursuant to an application by the petitioner, my lord, seeking withdrawal. Though, my lord, they have filed a withdrawal petition, but they contested on merit, my lord. They have submitted that some fraud were committed upon her, my lord, and accordingly, my lord, they paid for withdrawal of the application, my lord. Otherwise, assessment order, my lord, that was passed, my lord, after compliance, my lord, every, my lord, the preconditions, my lord, as prescribed under the Income Tax Act, my lord. All notices were issued, my lord, the email address of the assessee, my lord, that was linked with the PAN number of the assessee. And that has been, my lord, maintained by the assessee herself, my lord. And assessee also replied from the same email ID, my lord. And but could not provide any evidence, any documents in support of her claim, my lord. And therefore, my lord, section 69 attracted, my lord, and the entire amount, my lord, that has been treated as unexplained income. We have already filed a detailed affidavit, my lord. We have stated that all communications has been made, my lord, to the email ID of the assessee, my lord. And she has also responded from the same email ID, my lord. There are 9 of my affidavit in opposition, lordship. That regarding the statement made in para 17 of the writ petition, I say that all communication petitioner assessee had been done through online mode, that is email, mobile number, address, link with the PAN of the petitioner assessee as available in the database of the ITBA system and the petitioner SSC complied from the same given mail. So, my lord, all opportunities the SSC to produce the documents and evidences, my lord, in support of her claim that income accrued from the, my lord, area. However, my lord, no evidences were produced, my lord. That has been clearly reflected in the assessment order itself.
Who's the respondent number 9?
Mine is the private respondent.
You are respondent number 9.
Yes, my lord. My lord, this I already submitted before your lordship last time.
You're for the income tax department.
My lord, I am for the income tax department, respondent number 2 and 3.
But this affidavit is by 9, respondent number 9.
No, my lord. It is filed by respondent number 2 and 3, my lord. We filed our affidavit.
Oh, I see. Page 85.
My lord, I already submitted on so far my knowledge last hearing on 17th October that this petition, writ petition, the petitioner, learned petitioner, this is yes concealed and suppressed the facts of the order dated by your lordship, order dated 24/7/2022. Lordship, I think in that order, you have specifically mentioned in clause 5, which has been already explained by from the bank side, and I also submitted before lordship. The disputed question cannot be gone into the proceeding under Article 226 of the Constitution. Hence, your lordship already directed the petitioner to go to the civil court or lower court, and that petition was dismissed without prejudice. And moreover, my lord, I already submitted that two Supreme Court judgment. One is Subhashri Jain versus Rajeshwari Sivan and others. Another is Sri K. Jayaram and others versus Bangalore Development Authority and others for this, for the present concealment.
Lord, if I can.
In the proceedings, the petitioner was noticed.
My lord,
Lordship.
Against which SSC the proceedings were started?
My lord, against the petitioner, lordship. Lordship will find find it from the assessment order itself, my lord, at page 57 onwards, my lord.
Lordship,
Annexure
may I submit?
4.
Lordship, I'm not an SSC under the Income Tax Act, Lordship. My fake email ID was created in my name. Bank accounts were opened in my name. Mutual funds purchased in my name. And address was not mine. Even if your Lordship sees the bank transactions.
What? Page 57 is a notice.
Yes, these notices came, Lordship, in the portal of the email which was managed by the respondent number 9. It never came to my, that was not my portal of the income tax which I made, nor it was my email ID, Lordship. I have a separate email, my personal email ID for my office staffs and everybody, Lordship.
My lord, this is the order of assessment, my lord.
This order of assessments, Lordship, kept on going to the fake email ID of mine to the respondent number 9, Lordship. I have stated in my affidavit petition specifically, Lordship, I had procured the number to unlock it from his chartered accountant, and then I changed my password, Lordship. After that, I started receiving the late notices were in my email, Lordship. I blocked that email, which was being operated. All the notice of demand, all the former notices I never received at any point of time. It was received by an fake email ID created in my name by the respondent number 9, Lordship. This is my case, Lordship. And how can I answer to those evidence and how can I produce those papers which I never dealt with, Lordship? I filed a FI before the concerned authority. Charge sheet have been filed against respondent number 9 for that. His specimen signatures was taken. FSL report says that it is his signature. All in my name, the signature was put is not mine. It is his signature. Even one of the federal bank official, through the video conferencing, under no portion of the police, he states that he never saw my petitioner
Come to page 59.
Page 15 of which, Lordship?
59 of the affidavit,
My affidavit, Lordship?
petition.
My petition. Yes, Lordship.
A final show cause notice was issued on so and so.
These notices were never received by me.
The SSC complied to the notice.
Yes, Lordship, he replied to all these notices.
What can this court do? If this is a kind of a
Lordship, Lordship, I'm only on my limited prior, Lordship. Let them hear me personally. There's a faceless thing, everything is going on, where I'm in no way connected with all these transactions. These bank accounts are not mine, Lordship. I have been repeatedly praying before this court, Lordship. Lordship, they did not allow me to withdraw my review petition. That's the party who files the lease has every right to withdraw, Lordship. I am on the law point, Lordship. And neither the speaking order is passed. Why they have not allowed me to withdraw, Lordship?
My lord, in this case.
Wait 1 minute. Let me just finish my thing. Lordship will come to page. Lordship will come to page 108 and Annexure 18. These are the things I have challenged before this Honorable Natural Justice, Lordship. That is why I am here before under Article 226, Lordship. I have specifically stated in my withdrawal petition that I was not aware of this when I filed the review. Every notice was received in that fake email ID, Lordship. Every answer was given to it by the respondent number 9, Lordship. Annexure 18, page 108, Lordship. Paragraph. The SSC has submitted a petition for withdrawal of application for revision under 264 of the Act, stating that after getting a copy of the revision application from Shri Gopal Chandra Rai, income tax
Page?
Page 108, Annexure 18, Lordship. I am not on anything, Lordship. I am only on this. They did not allow me to withdraw my review petition, which I have every right to withdraw, Lordship. The SSC has submitted, Lordship, have got it? And they pass a non-speaking order, Annexure 19.
Page?
Page 110. I'm challenging these two annexures, Lordship, 108 and 1010. It's complete non-speaking order, Lordship. After I have come to know of all this, where I submit before them my FIR also, Lordship, nothing is done to give notice on our respondent number 9. The income tax files an affidavit in opposition asking me, saying that I did not file my answers. From where would I file my answers, Lordship, where I never have all those documents with me? Mutual funds, banks, whatever it is.
You have prayed for withdrawal of the application.
Lordship,
Why
without
did,
my review application, which I stated yesterday, Lordship.
why did you make the application?
Lordship, I have stated here. Her relation with Respondent 9 was very close, and at no point of time he would have done anything that she would not believe him. Lordship, she was put into fear, Lordship. In panic, she signed that review petition without going through the proper implications in that review petition, Lordship. Only after it was filed, she collected the things and went to the mutual fund office and the banks, and then she found out mutual funds to the tune of crores were purchased in her name. Bank opened without her knowledge, Lordship. Even in the Lordship, the police during investigation, Lordship, they got hold, or they asked, the bank produced the checks which were given by the Respondent 9, and those signature in the bank checks also is not my petitioners. It is the signature was that his handwriting tallied with Respondent 9, Lordship.
Anybody would be foolish enough to make such huge investments in the name of somebody else.
Lordship, that is
unless there is some promise
no,
of
Lordship, there is
reward.
not. Lordship, otherwise also, Lordship, if suppose this
Unless there is some collaboration.
No, Lordship.
Or there is some benefit out of it.
No, Lordship.
So
If it is so,
what kind of a fairy tale story?
no, Lordship, it's not a fairy tale story, Lordship.
Absolute fairy tale.
If at all these are my investment, I could have gone off with 26 of the Income Tax Act, Lordship. I could have.
You are claiming exemption under the Income Tax Act, so you may have become a haven for somebody else.
No, Lordship, no, Lordship.
Money.
No, Lordship, because the police report
You
is
go
there.
before the Income Tax Authority and clear yourself. We cannot go into those complicated facts. That the signature is not yours, the form is not yours, the bank account
Lordship,
is
then
not
I pray, Lordship.
yours, then
Lordship, then I pray, Lordship, let it be put in abeyance till the criminal case is done, Lordship.
What?
Lordship, already charge sheet has been filed. The case of the criminal case has started, Lordship.
this has got nothing to do with civil proceedings.
So, Lordship, here is a lady, Lordship, helpless, Lordship. If it was her money, Lordship, she can.
Anybody would be unwise enough. Would you do it?
They have done. He has done it, Lordship.
That your money is invested in somebody else's account.
Lordship.
Unless you are reaping some benefit out of it.
No, Lordship, I've never. Because, Lordship, if it, Lordship, kindly listen, Lordship. Kindly give a patience to my ear.
No, we have all the confidence and trust in you, but we are afraid
No, Lordship.
to say that your client
Lordship, it's
has misrepresented to you.
No, Lordship. No,
Madam,
Lordship. And that,
you are trying your best sincerely, but this is the impression we form.
so had that impression, Lordship.
So that you have been misrepresented by your
No,
client.
Lordship. If at all she was misdeed, she could have filed under 1026 of the Income Tax. Lordship will just listen.
Mr. Sharda, we can do this. The letter dated so and said paid for withdrawal of the revised application, revisional application. We can you consider the revisional application afresh.
Lordship.
Hearing me, Lordship.
That may be done. Lordship.
That this withdrawal was made by mistake, you consider afresh, hearing all parties in accordance with law by a reasoned order.
Lordship.
You do.
Lordship. And in the miscase, Lordship, till then I should be protected, Lordship.
What is the mistake?
They have filed, they have put me again into notice for recovery. So that miscase is filed yesterday, Lordship.
Madam, that can be considered by the revisional authority.
You make that application before the authority. That application will also be considered.
Lordship has already given the order, Lordship. If at all it was my money, under section 1026 of the Income Tax Act, a scheduled tribe is exempted from any kind of investment when it is, the earning is within the scheduled tribe area. So even if I would have earned 20-30 crores, they put me notice, I will reply to them showing where the income has come from and I'll be exempted.
Yes.
This is
But
why if you...
it did not end in that. You were trying to save somebody else's income also from taxation by taking it into your account.
No, Lordship, this account is not mine, Lordship. I have, Lordship, for my satisfaction, Lordship, will kindly see the charge sheet file, Lordship.
No, forget it. You go before the authorities and try to exonerate yourself.
Lordship. Till then, Lordship,
This application is there.
My Lord, I'm appearing for respondent number 4, 5, and 6, my Lord, for the state. And as far as the criminal case is concerned, my Lord, the FIR already charge sheet has been filed. That is pending for trial.
We have got nothing to do with that. The facts as disclosed in the records are these, full stop, paragraph. The petitioner is working as director in the Department of Soil, Government of Meghalaya. Full stop. She is a resident of Khasi Hills. Full stop. She claims to be member of a scheduled tribe as defined in Article 366 within bracket 25 of the Constitution of India, residing in Part Roman II of the table appended to paragraph 20 of the 6th schedule to the Constitution. Full stop. She claims exemption under section 10 within bracket. She claims exemption from income tax under section 10 within bracket 26 of the Income Tax Act 1961. The facts that we are called upon to adjudicate cannot be and are impossible to be adjudicated upon by this court in the exercise of its jurisdiction. Full stop. They are glaring, full stop. According to the writ petitioner, the respondent number 9, a stockbroker, mutual fund agent, empaneled valuer in several banks, mutual fund and PAN card agent. Practice fraud on her by opening and maintaining, by inter alia, opening and maintaining a bank account in her name, making false investments in her name, creating unauthorized email accounts, forging her signature, so as to portray a large income and investment on her part. Full stop.
My lord, I may be excused. I am on behalf of respondent number
Not
9.
now at the time of passing the order. These are all allegations. These are not the findings of the court.
So kind of you. My lord, I am to just for your kind perusal,
Although
just my lord, I may be excused. The respondent number, the petitioner, being a high official under the government of Meghalaya,
please sit down.
for 1 second.
Please sit down. That is the procedure. You make your notes with pencil after the order is dictated. You try to don't interrupt at the time of passing.
ठीक है, so kind.
Yes, please take note. Not although, full stop. Although the petitioner is not an SSC under the Income Tax Act 1961, the Income Tax Department was activated by this respondent to make the petitioner an SSC. Full stop. As a result of all this, the petitioner has become involved in income tax proceedings, full stop. She has also become involved in criminal proceedings. Full stop. In this, full stop. Broadly, in this writ application, the writ petitioner wants quashing of these proceedings. Paragraph. Where is the assessment order?
Lordship, assessment order is at page, Lordship, annexure 4, page 57. There are two assessment orders. One is at page 57 and another is for, my lord, at page 66, my lord.
For 2013-14 and 15-16.
14-15 and 15.
For 14-15, 13-14, 14-15. Two assessment orders are there, Lordship. One is annexure 4 and one is annexure 5, Lordship. Annexure 5 is page 66. The two for 2012, 2013-14 is annexure 4, page 57. And annexure 5, page 66 is for 14-15, 2 years.
We are shown two assessment orders, one dated 30th March 2022 for the assessment year 2014-15 and the other.
Same date, Lordship, on the same date.
For the assessment year 2015-2016. In 11/4/2021, what you had submitted? Page 108, before the assessment order.
Yes, Lordship, through the fake account, Lordship, 108, yes. This is NHA 18, Lordship, talking about?
Yes.
This is the order passed by the income tax officer against my withdrawal petition.
No, that is all right. The SSC submitted the application under dated 11/4/21.
Yes, Lordship, that was the revision petition which I filed and I wanted to withdraw it.
No, but assessment order is 22. Then 21, what did you file? 2020, or is it a mistaken date?
It is a mistaken date, Lordship. On the SSA submit application on 11/4/21. Lordship, it's a mistaken date, Lordship.
22 it should be.
Lordship. It is 16/4/22, Lordship. Revision petition was dated 16/4/22. It's a wrong date they have put here, Lordship. In the order, Lordship, it's a wrong date put. It was submitted 16/4/22. I have annexed the revision petition here.
First of all, the Income Tax Act 1961 provides a very detailed machinery for investigation and determination of income and its assessment to tax. Full stop. It also provides a structured system for assessment, preferment of appeals from such assessment, revision, and so on. So the writ petitioner has to avail of that remedy. Full stop. Secondly, the writ court as a writ court, we ought not to exercise jurisdiction to adjudicate upon highly disputed facts which will involve evaluating very voluminous evidence. Paragraph. We find, according to the records, bracket annexure 18 at page 108 of the writ petition, that on 11th April 2021, bracket, the date appears to be wrong, comma, according to learned counsel for the petitioner, it should be 16th April 2022, comma, the SSC had filed an application for revision under section 264 of the Income Tax Act to 264 of the said Act, for the assessment year 2014-15. On 9 June 2022, she withdrew it. Now, comma, learned counsel for the petitioner submits that her client had no hand in the withdrawal, and that was the handiwork of the respondent number 9. Paragraph. We are not going into the correctness of all the allegations made against the respondent number 9, comma, narrated here in above. Paragraph. We are of the view that this application for revision under section 264 be treated as pending, comma, after setting aside the alleged withdrawal of the application purported to be made by the letter dated 9 June 2022. Full stop. We direct the income tax authorities to hear the petitioner, comma, the respondent number 9, and all the interested and any other interested party, and dispose of this application by a reasoned order how much? 3 months. Within 3 months of communication of this order. The petitioner will also be at liberty to make an application before the income tax authorities for any interim order pending this proceeding under section 364 or 264 of the said act.
Lordship, I want to
My
point out
lord.
one thing.
My-
Lordship, I want to point out she is already retired now. When the appeal was filed, she was in service. This is one point. And the second, I have made categorical statement in the rejoinder affidavit to the affidavit opposition filed by respondent number 9 that even that income tax account, that income tax return file was not, that is very important to be recorded, Lordship, that income tax return file was never made by my petitioner.
Right. Where there is written up.
Lordship, Lordship, I have a small-
Make income tax return.
Your Lordship, as the petitioner mentioned the respondent number 9,
All points are kept open before the income
My
tax.
lord, one thing, in the writ petition, the petitioner already mentioned that the petitioner had invested some portion of in the mutual fund, not total.
It's a fresh hearing after the order or what?
No,
Right.
my lord, I tried to mention before your lordship.
We have stated in short the allegations,
Sir,
and we have also said
this may be also in the record.
we have not gone into the allegations.
My lord, it may be the petitioner being a high official under the government of Meghalaya, as well as aware that the provision of section 11(1) of the Meghalaya Service Conduct Rule 1990 creates bar to any government employees from investment, lending and borrowing, and the same specify that no government employee shall speculate in any stock, share, and other investment.
Speculate, but not long-term investment is not barred.
Sir, one-time investment also barred.
Long-term cannot be barred. You have to take the permission, that's all.
Now, permission is taken. It is also questioned, my lord. It may be, it
You
may
have
enter-
you have some investment.
I stated in my affidavit, Lordship, through him I made small investment before, not in this period, long back 2009-10.
However, the petitioner admits of having some investment
A small investment,
in her name out of her earned income.
Lordship.
whether it has been government order was taken or not, my lord. Government order is required. Any investment under section 11(1) of Meghalaya Service Conduct Rule,
No, even if a judge of the district court buys a car, he has to take a permission from the
whether she has taken, my lord.
Highly
She was
obliged.
the director of the soil conservation.
We have said all points are kept open.
So kindly, so kindly,
Highly obliged, Lordship.
I am obliged.
so kindly.
From the main list, item number 1.
Madam, thank you.
Yes.
My lord, may I please, lordship? My lord, we have been,
Meghalaya Power Generation.
my lord, the appellant is the corporation, my lord. My lord, on the last occasion, we were directed by lordship to prepare a paper book, my lord. My lord, I'm praying for some further time, my lord, at least 10 days time, my lord. We couldn't finalize it. So, my lord, with apology, I'm praying for some more time, my lord.
How much time required?
My lord, at least 10 days time, my lord, if lordship may kindly give me.
They have exhausted more than 1 month's time, my lord. Your lordship permitted them to file the affidavit, file the paper book on by 14th of November.
Are they enjoying any interim order?
No, Lordship.
There is not an interim order.
I'm the one who had been given the work, Lordship. My work is stopped, Lordship. After I invested 40 lakhs in that project, Lordship, my materials are lying there. There's no interim order, Lordship. I mean, item number 2, Lordship, I have challenged the
Same order, my lord.
same order.
You had been given the work.
Lordship, I had continued the work till 3 months, Lordship. When this petition was filed, I stopped it, Lordship.
Now the work has been given to you.
No, the work order has been interfered with by the Honorable Single Judge at the instance of the writ petitioner, whom I represent.
But not given to you.
No, not given to me.
He was the L2 bidder, Lordship. He was the L2 bidder. He challenged it. My work order, Lordship. He assailed my work order and the entire tender process. So I have, because since it was a long period waiting, Lordship, I had completed nearly 25% of the work, invested 40 lakhs there. My materials are lying there, Lordship.
If they want to file the paperwork, my lord, they can complete it even within this week, my lord. Your lordship can take up
Yes,
the matter in the
Lordship.
first week of December.
Lordship,
Even you have to file a paper with the next.
No, he did not tell me. Lordship, if they want any more time, it cannot be beyond 2nd or 3rd, Lordship, of the next month. If they can do it. This is just filing a paper book, Lordship. Why 10 days is needed?
My lord,
Already for that paper book, 1 month was given to them.
More than 1 month.
not exactly 1 month, my lord.
No, it's more than 1 month.
25th October, your lordship passed the order.
My lord,
asking them
if the
to file
matter is
paperwork by
urgent, my
14th.
lord, as per my friends, my senior, my lord, then we can proceed without the paperwork, my lord. Advocate General is reading this matter. We can have this matter even on Friday or Thursday, my lord, if paperwork is not necessary, my lord. Otherwise, since it is the direction of this honorable court, my lord, we would like to comply with this order, my lord. That is why I'm praying for further time. Otherwise, my lord, AG will be in a position to even argue without the paperwork, my lord.
Ninth is all right if we hear the appeal.
Lordship, yesterday I have stated before this court, I'm leaving, I'll be out of station from 5th, Lordship, taking my mom for checkup. That before 5th, Lordship, any day,
And you'll be back after the vacation.
back after vacation, Lordship. And my petitioner needs urgent hearing, the appellant needs urgent hearing because the work
Your
is
lordship
stopped.
can kindly accommodate us on 2nd or 3rd
Yes,
of
Lordship,
December.
I'm there.
Your lordship can kindly accommodate us on 2nd or 3rd of December.
All the papers are here.
Lordship, everything is there,
My lord,
Lordship.
it is a present.
It is a matter of regret that in spite of direction, the appellant was unable has been unable to file the paper book till date. Full stop. More than 1 month has elapsed since our order dated 25th October 2024, directing filing of paper books. Paragraph. Pardon? Second, how many matters are there? Hmm? And third? Third? All right, considering the urgency, list this appeal as the first appeal in the list on 3rd December. 3rd, you're here.
Lordship, Lordship, highly obliged, Lordship.
List, no, considering the urgency, the appeal would be heard on the available papers. Filing of paper book is waived
Both the appeals, Lordship. And in item number 2.
in all matters. List on 3rd as the first.
Item number 3.
My lords, you recall items number 3 and 4 are rate appeals pertaining to the MRI machine for the Tura Civil Hospital, my lords. The matters are listed today for arguments.
Lords, there has been a
There have
development.
been some developments. My lords, there have been some developments since in the meantime, my lords. I'll introduce the developments, my lords. What two things have happened? Firstly, my lords, in terms of the last order, the paper book has been filed and the awarded party has also carried out substantially the work, my lords. The MRI machine has in fact been received here. It's still in Guwahati, my lords, and given a few more days, it can be installed. Secondly, my lords, the opposite party, the discarded bidder, has moved the Supreme Court against the interim direction given in the last order, my lords, against the 30th of October order, where they have taken the position that since there is time being consumed in the consideration of the appeal, in the meantime, if the direction is allowed to continue, the entire MRI installation process will be completed and the proceedings will be rendered infructuous as per them. So, my lords, the Honorable Supreme Court has in the meantime stayed the interim direction which allowed Haring to carry out the work, and hence, my lords, since 18th of November, we have not carried out the work. But we have still reached 95% of the way, my lords. Lords, there is, however, no bar against the continuation of these proceedings and the final adjudication of the matter today. In fact, my lords, the grievance of the opposite side before the Supreme Court was that the pendency of the matter is coming in the way. Lords, I'll hand over a copy of the order.
It's already there, my lords.
My lords. Lords, the paper book has also been filed.
Something that my learned friend probably forgot to mention before your lordships is, my lords, they have again moved an application seeking.
That's only on the issue of interim,
May I just
of course.
finish? They've moved an
No,
application
this
seeking.
is an appeal to the Supreme Court against the interim order.
Interim orders passed by the song.
It's in SLP, my lords, against the interim order, where
In that, my lords, they have again moved an
We will
application
not
seeking
touch the
direction.
appeal anymore.
however, my lords,
Demand, my lords.
however, my lords, that is only the issue of the interim injunction is,
That may be, but the whole issue is before the Supreme
Supreme
Court.
Court, my lords, and they have filed an application seeking direction.
Unless the Supreme Court says that the High Court can proceed with the appeal, we should not touch it. Let them take care of the appeal also.
lords, but however, lords, I'll just point out a few things, lords. In the SLP, it is their grievance that the matter is not being decided here, and thus the interim order ought to be
You
vacated,
see, try to
my
understand.
lords.
If we hear the appeal,
My lords.
number one, the circumstances might demand that we pass another interim order in the appeal. It is possible.
Very much.
Another interim order in the appeal is possible with
My lords.
some change in circumstances, some passage of time.
My lords.
All right. It is possible to dispose of the appeal in derogation of the Supreme Court order. All right. The Supreme Court has stopped the work. The result of the appeal might be continue with the work. Right.
My lords.
So we are adjourning this matter till after the vacation. You see what happens there. The Supreme Court is open at that time. Or you seek specific leave for this court to proceed with the appeal. We will.
My lords, they have already moved an application.
Lords, the application that they moved is only, the application that they moved is only that the interim order ought not to be, the interim order that has been passed may be vacated. Lord, it's nothing to, on the effect of the continuation of the proceeding.
You also make one prayer before the Honorable Supreme Court
My lord.
that leave be given to the High Court to proceed
Proceed with the
appeal.
matter.
That's all.
My lords.
Matters coming up in any case on.
Lords, Lords, I bow down to the to what my lords has pointed out that if there's a subsequent interim order, it may not be proper.
We are
But lords,
absolutely agreeable with what you say that an appeal from an interim order does not prevent the main appeal from being heard.
my lords.
But you see, some sensitivity may be involved. That's why has the High Court proceeded and passed an order which is contrary to our interim order, etc., etc. So,
Very well.
you just wait till after the vacation, come back, and we'll hear it out. If
My lords.
Item number 3 and 4.
Yes, my lords.
Items
Both
3
are
and
connected.
4.
3 and 4. Considering the pendency of the appeal before the Supreme Court, pendency of the special leave petition before the Supreme Court. This number, huh? Top rate.
26923 of 2024, my lords. 26923.
Comma. By consent of learned counsel for the parties, we adjourn both the appeals till the first Thursday on reopening of the court after the Christmas vacation.
My lords, not with consent of the parties, my lords. That will come in my way, my lords. Not with consent of the parties.
Who will come in your way?
My lords, this recording might come in the way, my lords. My lords, please.
All right.
My lords, not with consent of the parties, my lords.
We think it fit and proper to adjourn.
My lords.
Nobody will come in your way.
My lords.
I'll oblige.